This is AM 650's The Law Show with Stirling Faux. Now back to the show.
Welcome back. In studio with us, we have Angela Thiele and Christine Eilers from Lindsay Kenney LLP. And on this episode of The Law Show, we're talking family law and some of the issues surrounding divorce and separation. We've talked about disclosure requirements, the dreaded Form 8, whether all parties are required. It is a requirement, isn't it, Angela, in British Columbia?
Absolutely.
You have to make a declaration of your assets and liabilities, and both parties are required to do that.
Absolutely.
Okay, so then we've got that done. We talked a little bit about real estate, Christine, with the house. Generally speaking, most couples' prime asset is their home, followed then by other mutual holdings, perhaps some real estate in the form of rental properties or stocks or bonds or RRSPs. Next, in terms of assets, would probably be pensions. And for AM 650 listeners, most of us are, fantasizing about being pensioned off and not having to go to the salt mine on Tuesday. Yeah. But pensions, how much of a factor are pensions when it comes to the division of assets in a separation and divorce situation?
Yeah, well, they're a big factor. I mean, first of all, pretty well everybody's got their CPP that is normally equalized at the end of a marriage. But beyond that, a lot of people have private pensions or government pensions or other pensions like that typically need to be divided at the end of the relationship in one way or another.
How do you mean CPP gets equalized? What is that?
Well, if one person has made many more contributions over the years than the other person, then that will be distributed such that the parties will get equal CPP payments at the end of the day.
Oh, I see. So the government, suppose now one partner is getting the maximum, and it's not much. It's maybe $1,000. Let's use that for round numbers. Let's suppose one party is getting $1,000, and the other, not having worked as long, raising children and whatnot, is entitled to only maybe $500, again for round numbers. So then, as a result of the negotiations between the pair, does the government of Canada get instructed to change both of those payments to $750 each?
It's basically just a simple form that needs to be submitted to the government, and they'll do it for you.
Oh, you see, now this is again, it's all about education, isn't it, on the Law Show? I think most of us assume that whatever Canada Pension Plan money comes our way, however petite that amount may be, it's ours. Absolutely ours, because we've worked for it, and whatever we get is our entitlement. It's the least the government could do for all those taxes we paid all the year, and that's not the case. It too is a subject of negotiation.
It's not even really a subject of negotiation. It's pretty well automatic at the end of the day.
It's pretty well mandatory.
Okay.
You know, you'd never give up your CPP split because, you know, if you've been out of the workforce, even though it's not that much money, it's more than nothing.
Well, sure, it's cash flow.
Yeah.
And what about the OAP, the other federal item?
Everybody gets that at 65, so and it doesn't change whether you've worked or not worked.
Exactly. So that's a fixed amount, and that just continues to each individual.
Yeah,
right?
Sometimes you have a bit of an issue where there's a spouse that's enough older that they're getting the OAP and the wife isn't yet getting it, so that's equalized with spousal support until she gets to that age.
Okay, but on the matter, for example, of a company pension plan, now those are in a real state of flux these days. Not all the way they used to be. You know, used to be able to work for 35 or 40 years. They gave you a nice party, a gold watch, and a fat pension, and off you went. They're all not defined pensions anymore. There are a lot of flexible plans and so on. How does the dissolution of pension benefits get resolved?
Well, fortunately, in British Columbia since 1995, we've had the ability to just send a form and I think about $500 to the pension administrator and say, you know, I'd like my share. If there's a message I'd like to get out to your audience in terms of the demographics, that wasn't the law until 1995, and I know there are thousands of people walking around with a separation agreement or a court order that says you're entitled to a share of your husband's pension.
Right.
Probably 20 years ago they got that separation agreement. They're now coming up to divorce. They probably haven't done anything about it because they didn't know what to do with it at the time. I fairly frequently get a phone call like that. I'm 58. I think my husband's going to retire. I remember something about a share of the pension a long time ago. Don't know where my separation agreement is. do you think there's something there that I can get? And now, because we have the ability to file something with the pension administrator, we can take care of that for them. But if they don't know and the husband just goes off and, starts taking his pension, then
Right.
they're not going to have much leverage.
Would it be 50% again automatically?
No, what happens is that from the date you marry to the date that you end your relationship was your share. So let's say...
Oh, I see. Okay.
Let's say you got married at, talking to your demographic, let's say you got married at 20 and you were with a fellow for 20 years and you split up in 1994. Nothing on the books, didn't know how to do it, but in your separation agreement it said, I get my share.
Mm-hmm.
So now here you are, you're 17 years later, 18 years later, there's now a statute. You get your share by bringing that separation agreement into a lawyer or into the union pension office, the company pension office, filling out a form, giving them $500 and or $750 maybe if it's a government pension plan, and say, before my husband retires, I'd like my share of my pension. And I know there are women out, because it's usually women out there, because I've had those phone calls.
Right.
And then when you find out how much it is, I had one not that long ago. Husband had worked at UBC, and she was like very sort of meek and mild, and Angela, what do you think about this, and how much do you think I'll get? And I looked at it, and I said, I think you'll probably get around $150,000. And she just she went sort of blanched, and in her mind, she was coming to see a lawyer. She didn't have a lot of money.
Right.
If I'd told her it was $20,000 she was going to get, she probably would have just walked away.
Right.
In fact, it was about $200,000.
Well, okay.
So people do not realize how valuable these things are.
Mm-hmm.
And what about, though, if the terms of the divorce, if there is a pension at play, Christine, is it automatic that the terms of the divorce will include an allocation of a percentage of those pension benefits to the other spouse indefinitely?
Normally that's the way it works, is that the spouse will receive a portion of the other spouse's pension, and that will happen when the one spouse is eligible to receive their pension. Sometimes people want to buy their pension out, so they want to keep their own pension. They don't want their spouse to be getting any of it upon retirement, and that can be done in some instances. You just need to get a proper valuation of the pension.
What about a situation where both parties have been enjoying successful careers and both parties are entitled to their pension benefits based on their work history, and there's not really a need necessarily for, I want some of his action too because I'm that angry. How do the courts consider that when both parties already, Angela, have pension funding in their separate lives?
Well, you're entitled to a share of his, he's entitled to a share of yours.
Oh, okay.
So unless you absolutely know that yours and his are absolutely identical, you're going to say, well, I'll pay the $600 to get my share of his, you pay it, for me, and then whatever happens when we retire happens. You can't look at two different pension statements very easily and say this is worth the same amount as this, because two major different types of pensions, what we call defined contribution, which is like a group RRSP, defined benefit, which is a percentage of his income as long as, when he retires. And, so I virtually never tell someone to give up their pension, and I virtually never tell somebody else. They'll say, I want to keep my pension. I'll go, well, you might not live long enough to get your pension. Do you really want to give away a bunch of cash now on the basis that you'll have all this, pension when you're 65? You could drop dead and in the meantime not have been able to buy a house, hoping to get to that pension at 65. So there's a lot of consideration of what you're going to do.
All right, and in terms of trying to figure out the numbers, Christine, to perhaps do a buyout and just keep the decks cleared and keep the clutter to a minimum, are there professionals that do that sort of work? That would it be an accountant or a tax lawyer, or who do you seek out?
There are actuaries who will do that calculation for you, and it can be expensive depending on the type of pension, and there's a lot of different contingencies and factors that need to be worked into the valuation. So, but it can be done.
Okay, so I think the bottom line when it comes to pensions, though, two things. One, never assume anything when it comes to pensions and who might get what portion of what. And the other part would be, I guess, Angela, is it open-ended? Is this just going to carry on until one of the two parties actually passes on, or is there a finite limit to how many years you can receive a pension benefit based on a divorce settlement?
No, it normally carries on, and once it becomes, once there's a split, it's your pension. It goes with your life, your life experience. So, the good thing about splitting is if the pension, let's say you think your husband doesn't have much of a life expectancy, you go and actuarially they're calculated based on a life expectancy of 82 or 85. But maybe your husband is in poor health. So you're saying, well, let's split it because my part I get for as long as I live. And the other thing, and I have a personal pet peeve that I was going to put on the radio. There are some employers in this province that still will not follow our pension legislation properly. And I have had to litigate against Air Canada a number of times to say, look, would you do this the way everybody else in this province is doing this? So it's the one time you can have an issue is when you have a particular employer that does it a different way.
Right.
And recently the court has said to Air Canada, no, you must follow our pension legislation, and that was the case I did.
Okay.
So that's why I have a personal pet peeve, because it costs that client a lot of money to get Air Canada to follow the same rules that everybody else in this province has to
so
follow.
basically, in BC, there is a formula, so let's play ball here and get it done, right?
Yeah.
You're listening to The Law Show with our partners from Lindsay Kenney, Angela Thiele, and Christine Eilers in studio. We're talking family law on this Thanksgiving weekend. I'm Stirling Faux, and we'll be right back.
There's more of the show still ahead. This is AM 650's The Law Show.